5 seconds to go. Start. It is further submitted by Shri Mehta, Learned Solicitor General, appearing on behalf of the appellants that even otherwise the High Court has erred in holding that as the award was not declared and the possession was not taken over, Section 24 of the Act 2013 shall be applicable. It is further submitted that the High Court has failed to appreciate that the award could not be passed on account of stay order granted by the High Court. It is submitted that therefore non-passing of the award, which was due to the stay granted by the High Court, cannot be a ground to apply Section 24 of the Act 2030. Making the above submissions, it is prayed to allow the present appeals. Present appeals are vehemently opposed by learned counsel Sunil Fernandez, appearing on behalf of the respondents herein, original writ petitioners. It is submitted that in the present case, as neither the possession of the lands in question have been taken over nor the compensation has been paid, as the award was not declared, no error has been committed by the High Court in directing to pay the compensation under the Act 2030. It is further submitted by the learned counsel appearing on behalf of the original writ petitioners that in the present case neither clause 213 of the Jammu and Kashmir Reorganization Removal of Difficulties Order 2019 nor Section 6 of the General Clauses Act 1897 shall be applicable. It is submitted that reliance placed by the appellants on the decision of this court in the case of Bangalore Development Authority and another Supra is wholly misconceived, as the same shall not apply to, to the facts of the instant case. It is submitted that in the said judgment it was held that the repeal of the Land Acquisition Act 1894 would not affect lapse the land acquisition proceedings initiated under the Bangalore Development Act 1976 inasmuch as the provisions of the former act had been incorporated into the later act and therefore had independent existence. It is submitted that in the said decision, the view taken by this court was on the premise that since the governing statute, that is, the Bangalore Development Act 1976, had not been repealed, there was no occasion of applicability of the Act 2013. It is submitted that in the present case, J and K Act, which was pari materia to the Land Acquisition Act 1894, stands repealed and Act 2013 has come into force with respect to the J and K with effect from 31st October 2019 on enactment of the Jammu and Kashmir Reorganization Act 2019. It is further submitted that in view of the plain language implied in section 24 of the Act 2013, that is, if at the time of commencement of the Act 2013 no award has been made under the old Act, then all the provisions under the new Act Act 2013 relating to determination of compensation shall apply. Stop.